More pushback around EEO1 federal pay data collection. Hi, I'm George Whipple. On August 16th, the Department of Justice appealed the district court's ruling that reinstated the Obama-era pay data collection rule. This appeal comes just before the September 30th collection deadline, but the briefing schedule in this appeal extends beyond September 30th, so there's little chance of resolution before the EEOC's reporting deadline. Commissioner Lipnic has said that nothing will stop employers' obligations to submit the data on time. The appeal raises significant questions about whether and how the data will be used.
The Justice Department claims that the court erred in two ways. One, that it found that the plaintiffs below had standing to bring the suit from a harm perspective. And two, that the court erred in directing EEOC specifically in the manner in which the data would be collected. So we're recommending to clients to continue to prepare for the filing, but to hold for a bit until the end of September prior to the deadline, but hold until we have a little bit more clarity from the court about what direction this could go. The interesting thing about this data collection exercise has been about pay equity more generally. What is the purpose in conducting a pay equity audit? The purpose of doing an audit under privilege, we would recommend, is to find out what's going on in your own comp system. Not to say that you're being discriminatory in any way, shape, or form, but to really understand what's going on. Every time you hire someone or terminate someone, you change the pay scales or the pay direction that your organization is in. So looking at it routinely is a good practice. It's a good business tool to manage your workforce.
More worker protections coming online in states across the country. New York passed new legislation that prohibits discrimination based on religious facial hair, clothing, or other religious attire. The new law comes as part of a package of legislation that increases worker protections in harassment and discrimination claims and settlements. This expands upon last year's groundbreaking sexual harassment legislation. In Illinois, Governor J.B. Pritzker signed similar comprehensive legislation that, among other things, limits arbitration agreements and non-disclosure clauses, mandates sexual harassment training, and extends job-protected leave to victims of gender violence. Illinois' legislation goes into effect January 1st, 2020. New Jersey has enacted sweeping new legislation that includes heavy penalties for failure to pay wages. New Jersey employers could now face triple damages for wage claims and even typical contract claims. And the new law also extends the statute of limitations for minimum wage and overtime claims.
The law became effective immediately upon signing on August 6th. Whether it will be retroactive is an issue that's likely to be decided by the court. However, the New Jersey Department of Labor appears to have taken the position that it is retroactive. Among the things that employers should do now are, 1, make doubly sure that all your employees and independent contractors are properly classified. 2, ensure that your non-exempt employees record every minute of their time. 3, review your employment agreements, including your commission plans and bonus plans and executive agreements, to make sure there are no ambiguities, and where possible, include that payment is dependent on employer discretion. And 4, don't forget about your handbook. Make sure your contract disclaimer is airtight.
Thank you so much for watching, and we'll see you next time.